So when you approach the podium, please clearly state your name and who you're representing, and smile. You will be on YouTube in a couple of weeks. These are all available on YouTube after a certain amount of time. So with that, counsel for the appellants.
Good afternoon. My name is Stephen Biggs. I represent the appellants. I won't name them all either. I will refer to them as the Marsh Group for simplicity purposes. To begin with, I want to explain why this case is not controlled by ML Servicing Co. v. Coles, which was decided a year ago by this court. In ML Servicing Co., the successor to Mortgages Limited sought to recover the life insurance proceeds, some of the same ones that are issued in this case, in the hands of Ashley Coles and originally Francine Coles as well, though the appeal relating to those proceeds was dismissed. In that case, the argument by the ML groups was that they were the owners of the funds that were used to pay the policy premiums, and therefore they should be allowed to recover those funds that had been misappropriated by Scott Coles. This court held that the ML parties were not the owners of the funds because policy proceeds don't come into existence until after the death of the insured. And in that case, the time when the premium payments were misappropriated, obviously the decedent hadn't died and there was no ownership interest. Therefore, the court concluded that the ML groups were creditors. In this case, there's a difference. In this case, we have a statutory constructive trust that has been imposed by operation of ARS 13-2314.04 D6. And I will probably just refer to that for simplicity as the D6 statute from here on out to avoid repeating all of the numbers and getting them wrong. The D6 statute says that property acquired by an enterprise or a person through a racketeering offense or a violation of the statute that criminalizes illegally conducting an enterprise becomes subject to a constructive trust for the benefit of the victims of the racketeering. The statute also specifically says that constructive trust follows that property into its proceeds and fruits.
If we disagree with you on that argument, then haven't you tanked your argument and in trying to distinguish ML servicing?
If you disagree on the ownership and the policy proceeds, I think that is a difficult hurdle for us to overcome if you disagree with us on that. Okay. I do believe that the clear language of that particular statute, the D6 statute, does say that the constructive trust goes into the property, which here would be the life insurance policies, and follows it both into the proceeds and the fruits. I think there can be no question that life insurance proceeds are proceeds or at least fruits of a life insurance policy. Therefore, under our reading of that statute, the constructive trust would follow that into the proceeds.
But that also assumes there's been a determination, or you're entitled to pursue a determination of liability, doesn't it?
Correct. And so one of the bases on which the appellees have argued and the Superior Court determined that our claims were dismissed was because the Superior Court, I think, implicitly determined there could be no determination of liability once what I'll call the racketeering claim against the auditor defendants and lawyer defendants and the financier were dismissed. That determination of liability language I think, was misread by the court and by the Coles. The determination of liability can be made as part of our prima facie case for why we're entitled to a constructive trust. There doesn't need to be defendants there to defend against determining whether these proceeds were acquired either through a racketeering offense or through a pattern of unlawful activity. That can be determined as part of the prima facie case where the Marsh Group establishes why it's entitled to a constructive trust.
Undercut the protections given to, I'll call them innocent people, under 2314.04 subsection L?
No, it does not, because subsection L applies to in personam proceedings where you're seeking to hold somebody liable. So for a personal liability, natural persons cannot be held liable. A constructive trust remedy, as our courts have interpreted it, is a quasi-in rem proceeding. and a quasi-in rem proceeding seeks to affect the interests of particular persons in particular property.
You know, forgive me, I missed that citation in the brief. So your authority that is quasi-in rem is based on what?
I will give you a citation. The authority for that is 129 Ariz 362. That specific case was not cited in the brief.
Was the point cited in the brief?
Yes, the point was made that this was, the point was made in both the opening brief and the reply brief that the subsection L, I'll call it, is seeking to impose imposition of personal liabilities, imposition of liability, whereas D6 is talking about seeking property, and it's pursuing property through a constructive trust.
Forgive me, Mr. Biggs. Subsection L is pretty broad. It says, shall not, a natural person shall not be held liable in damages or for other relief. Whether it's quasi-in rem or something or other, it's a constructive trust is a form of relief. So how do you, this is what has caused me that I'm just not sure I'm on board with your argument. Let me put it that way. Why isn't the constructive trust here a form of other relief?
It may be a form of other relief. I think you have to read that in conjunction with held liable for other relief.
Right.
So a natural person shall not be held liable for other relief. Through a constructive trust, you're not seeking to impose personal liability on, in this case, the Coles.
I agree with you about personal liability, but you're still seeking to claw it back. And the clawback is going to operate against a, in this case, a person. So in that sense, that person is liable for other relief. It's just that maybe is not directly, well, it's affecting their pocketbook, but it's not something as we'd say like Judge Kessler is liable because he almost rear-ended me this morning. He really didn't, but he came close. Versus clawing back the monies.
And I think that it's because of the term liable. Liable can have many different meanings. In this context, I think in context of the statute, it must be read that subsection L is referring to personal liability. Part of the reason is the interplay between subsection L and subsection D6. Subsection D6 creates a specific exception. That exception is for a bona fide purchaser for value who is reasonably without notice of the unlawful conduct and who is not knowingly taking part in an illegal transaction. If you were to read subsection L as applying to D6, you would virtually have to read that exception out of the statute because subsection L more than engulfs that exception.
But can't statutes, our legislature sometimes moves in mysterious ways. And can't the legislature decide to protect bona fide purchasers or innocent people in a couple of different ways? The first section requires there to be a bona fide purchaser in exchange for value. And the L doesn't require the exchange. So there are some distinct differences. And yes, there's a little overlap, no question about it. But that little bit of kernel of overlap doesn't mean they are in conflict or they don't have different purposes. And there's quite a bit of case law that says that Congress or our state legislature can decide to go at a problem in a couple of different ways.
And I do understand that dilemma. Here, I think it does talk about a bona fide purchaser for value, but it also says they have to be reasonably without notice of the unlawful conduct and have to not be participating in it. I can't think of a single instance under which somebody could be a bona fide purchaser for value who is reasonably without notice of the unlawful conduct and who is not knowingly taking part in the illegal transaction.
Isn't that the point? L doesn't require someone to be completely without notice. L requires the person basically to not have, I'll use one word instead of the multiple words the legislature selected. It requires someone to not participate. You may know, but I wasn't involved.
Correct. And subsection D6 also requires the person not to have taken part in the illegal transaction. So there is a complete overlap there. If you were to read it that way, there would be no reason for the legislature to create this exception in D6 because all of the circumstances would have been covered by section L.
That's just a small little bit, that's just a small overlap.
I don't think it's
I don't see one superseding the other or rendering one section so redundant as to say that, well, we have to interpret them differently.
I think it's that it renders that exception meaningless rather than just redundant. there's no reason to have it. And the legislature passed these two subsections as part of the same statute.
Well, you know what, I'll tell you, on that point, I do disagree, because having looked at the legislative history really closely on this, because you made that point, at least my understanding of the legislative history is that, give me a moment here. The legislature first enacted the RICO statutes in '78. When the statute was first enacted, 132314 governed both civil RICO actions filed by the state as well as private plaintiffs. Then in 1985, the legislature enacted the language that is in D6. Okay? That was part of their efforts to expand RICO remedies. Then in '93, the legislature decided to basically tone down the availability of RICO remedies. And that's when it enacted two separate statutes. It took the same statute and it divided it in two. And one part of the statute went to public RICO claims, the AG's claims. And the other statute, that is the one we're dealing with now, dealt with private party RICO claims. And that is when subsection L was inserted into the private party statute, not when, and the legislature did not insert it into the AG statute. So L, you're, in a sense, you're technically correct. When the private party RICO statute was created, it had both sections. But L was new as of 1993. It didn't pre-exist.
Correct. It didn't pre-exist, but I think that I interpret the legislative history a little bit differently. When the legislature created 2314.04, I don't think it was just merely a transfer and separation of the AG's right of action and the individual private plaintiff's right of action. I think the legislature made substantive changes. It added the pattern of racketeering requirement to an individual plaintiff to differentiate it from the AG's, and it created a new section where it did go through and make some changes, and I think that it's an enactment of a single statutory scheme right there that the legislature did. And if they had wanted in adding L to have that exception apply to D6, they could have done so. In fact,
But the point is, D6 always existed. It existed pretty much from the get-go. And so when the legislature enacted the private RICO statute, it carried over D6, and then it also inserted L. But they did not exist at the same time from the beginning of the legislature's enactment of the racketeering statute.
In the exact words, no, they did not exist.
Okay.
I agree with you that L was added as a completely new, that language did not appear in the statute before 1993. I agree with that.
Okay.
But I believe nonetheless that the legislature, we have to presume it understood what it was doing when it enacted a statute. I understand the legislature moves in mysterious ways. In this case, I believe that it enacted one statutory scheme for private plaintiffs, and as part of that statutory scheme, it decided to create constructive trust remedies, which it also allowed when the AG brought an action. It created exceptions, and then it also limited the personal liability that could be imposed on a defendant when an actual racketeering claim was brought, and that's subsection L. And I believe that the context is that subsection L should be read as applying to an actual racketeering claim seeking to impose personal liability rather than a constructive trust remedy that's really pursuing property in the hands of third parties. I would like to reserve, unless there's another question ready.
What would be the value of protecting somebody from personal liability if their personal property wasn't protected as well?
Well, the personal property...
What does that do?
I think here the personal property, the matter is here that these are innocent, gratuitous donees.
No. I'm asking you, you say that L is only directed at personal liability. It only protects you from personal liability, and D6 is directed at property. Well, if you're personally liable, your property is liable. So why would not L protect you from personal liability, damages, and your property that could be collected or executed on a judgment? That wouldn't make any sense, would it?
It does make sense in this case. So, for example, personal liability, somebody gets a judgment in personam against another person, they can pursue any property of that person. through proper attachment once they have the judgment. In this case, with a constructive trust, the Marsh Group can only pursue certain property. It's particular property.
Money is fungible. Forgive me. I wish I had the 40 million, but money is fungible. So the $1 that Ms. Cole has is the same as the other dollar. They look exactly the same. So which dollar is it? And moreover, if in fact the Cole's defendants have used that money to buy other assets, which I believe some of the monies have in fact gone into various entities, then to pursue the quote property, you're going to have to pursue other assets belonging to them. So how, getting back to Judge Gould's question, how is that a different?
It goes to the fruits and proceeds. There may be some tracing issues that further down the road that we will have to deal with. At a motion to dismiss stage, we're not there yet. And I admit those may be some hurdles we have to overcome later on. But this case was resolved on a motion to dismiss, and we're talking about whether the statute, as a matter of law, allows or disallows this. And our reading of the statute is that the statute clearly imposes a constructive trust, and the Marsh Group is trying to follow that constructive trust to recover property. I understand the difficulty that money looks the same, and there may be some tracing issues, but the truth of the matter is we're not there yet.
But it does go to your statutory argument. I mean, because you're making an argument that the statute allows you to go after those.
Yes, correct. And so if
that we have to address it now.
Well, I don't think there's been any contention or part of the motion to dismiss that the allegations were insufficient, that what is being pursued through this constructive trust was not acquired.
I understand that. I'm just saying that we have to look and we have to understand why there's a difference between L and D6, and one of them is if you're going only after property, but you can go after the fruits and proceeds of that property. It's the same thing as almost the same thing as personal liability. Maybe you have to do a little tracing, but it could be almost anything.
But I do think what you said, there's probably going to have to be some tracing there. So I don't think it could be almost anything. I think that there's going to have to be tracing to connect it and show its fruits and proceeds.
At least as I understood L, it also protected those with some knowledge of the unlawful activity. I mean, it could go that as long as you didn't participate. You didn't participate, authorize, request, command, ratify, or recklessly tolerate it. You might have some knowledge of it. Whereas D only protects the bona fide purchaser with who is ignorant of the law, because you can't be bona fide purchaser if you know about the unlawful activity.
Correct.
So that would be a difference between the two statutes, right?
Well, I think that the recklessly tolerating the unlawful conduct of another, I think if you know about it, there's probably a great likelihood you're recklessly tolerating it. That if you know about it and you're not doing anything, there could be some room maybe for some negligence there, but negligence usually somebody doesn't actually know about the wrongful conduct and isn't letting it happen. So I think there is a difference there.
But I mean, there could also be that you should have known about it. I mean, or would you say if they should have known about it, they might be you might still be able to go after the proceeds?
Are you talking about under D6 now or L?
Either one.
Either one. Under L, whether you should have, if that falls within,
should have known.
If there's a reckless element where the should have falls under recklessly, I think possibly. On D6, it's without notice of the conduct and not knowingly taking part. So under D6, if you didn't, you have to not know. I don't think there's a should have known element in that under D6. I would like to reserve some time, but if you still have questions, I'll go ahead and answer those.
We're going to add 3 minutes onto his time. We give him a lot of questions. So when he sits down, if you'll add 3 minutes, and then add 3 minutes onto the other side also. So they'll have 23 minutes.
Okay. Thank you.
That's my fault. So you can subtract 2 questions from my 5 questions that I asked.
Okay.
I was hoping we could subtract all of your questions.
So his time left would be 4:07, I think, Kate, and then 23 minutes. And just give us a minute to get this straightened out. Okay, thank you. That's fine.
May it please the court, Todd Feltus on behalf of the applicant Ashley Coles, and Mr. Elwell and I are going to be splitting up our time. I'm going to talk about why ML Service, or subject to Your Honor's question, is going to talk about why ML Servicing versus Coles does dispose of this case. And this was a case I argued a year and a half ago before another panel of the Court of Appeals. And I guess to kind of lead in from what Mr. Biggs was arguing about this whole notion of personal property and quasi in rem and all of this, from a practical standpoint, if we were to go back down to the trial court and we end up with a judgment at the end of the case, it's going to be directing the defendants in this case to pay money to the plaintiff group. I mean, I think we can call it personal liability, we can call it quasi in rem, we can call it a constructive trust. The end result is going to be, if the plaintiffs were to prevail, is the defendants will owe them money. And that's really where the ML Servicing case in 20-1131 bars this claim right now on a motion to dismiss as a matter of law. And under that statute, a creditor of a person who affects life insurance cannot recover against the life insurance beneficiary. And there are a couple elements there to unpack. The first is creditor, and we spent a lot of time in the ML Servicing case unpacking the notion of creditor. And what the Court of Appeals said was a creditor is simply someone who owes someone else money. And the Marsh Group here is saying these folks owe us money. So the definition of creditor is broad. It would encompass the situation that ML Servicing was coming into court and saying, hey, we own the insurance policies. These monies belong to us, and Scott Coles took it from us. And so we're not really a creditor. This was ours to begin with. And the Court of Appeals said it does not matter. You owe someone money, you're a creditor. You fall under the statute. So pretty crystal clear under a broad definition, and I think that any way that you pitch it, whether it's as a constructive trust claimant, as a plaintiff in a personal liability case, as a victim of unlawful conduct, which is what the Marsh Group tries to portray in the group, it really doesn't matter. The claim is they owe us money, they're a creditor under the statute. And that's the law in this jurisdiction.
Wasn't the allegation against Scott Coles? That's my understanding. The allegation, at least my understanding in the complaint, was that Scott Coles knowingly used illegal proceeds, and therefore Scott Coles is liable.
Yeah, no, that's absolutely correct, and that's a nice segue kind of into the second point, that Scott Coles was the one who affected the insurance policy, and that's, we spent the time unpacking that in the ML Servicing case. So it was, the plaintiffs here, the Marsh Group, saying Scott Coles owes us money for his wrongdoing.
Therefore, they're a creditor.
They're a creditor of Scott Coles. Therefore, and Scott Coles effectuated the insurance policy, and they dance around that a little bit, particularly in the reply brief, the Marsh Group does. But the first amended complaint, if you take a look at paragraphs 799 through 801, it lays right out that the 799, Scott Coles arranged for and put in place life insurance on his life in excess of $50 million. And then it goes on that in 800, Scott Coles knowingly used illegal proceeds from the illegal enterprise to acquire life insurance policies. So under the allegations of the first amended complaint, which we all must assume to be true, Scott Coles was the one who affected the life insurance. So if Scott Coles is the creditor, and I agree with Your Honor on that point.
The debtor.
What's that?
Scott Coles wouldn't be the creditor.
No, the Marsh Group would be the creditor.
Marsh Group would be the creditor of Scott Coles. Yeah,
yes. Gotcha. So, and because Scott Coles is the one whom the creditor is seeking the claim against, they can't recover from any of the beneficiaries of the life insurance policy that he acquired. And you reach the same result even if you do the dance that the Marsh Group does in their reply brief and say, well, it wasn't Scott Coles, it was the illegal enterprise. You run into the same roadblock under the statute, because if it's the illegal enterprise that affected the life insurance, affected the acquisition of the life insurance, then what the plaintiffs are saying is that they are the creditor of the illegal enterprise, and they still can't recover against the policy beneficiary. So either way, either way, they just run into a complete roadblock under the first part of 20-1131. The second part of, and it's really more the result of ML servicing and also the estate of King case, it's just an absolute showstopper, is the notion that policy proceeds are not property. And we have 2 cases now in the last 3.5 years out of this court that's reached that conclusion. And that really stops everything, because for the constructive trust, even under as it's formulated by D6, because D6 talks about a person or enterprise that acquires any property. Well, the property at issue here is the proceeds, or what they're trying to seek as property is the proceeds, and the proceeds aren't property. And we know this from Estate of King. We know this from ML servicing.
My recollection of the State of King was pretty clear the legislature was trying to protect beneficiaries of life insurance policies.
Absolutely. No, there's no question about it, and that's
legislative intent.
That was absolutely the legislative intent, and you can look at May versus Ellis, which would have been the Supreme Court case from 2005 that would really form the basis of where King was coming from. So that's absolutely correct, and with that legislative intent, with it not being property, it prevents a constructive trust claimant from coming in and trying to take the insurance policy proceeds, whether it's proceeds or fruits from the policy or not. You don't get there because it's not property in the first instance. And then finally, the distinguishing characteristic that the Marsh Group just argued from ML servicing is that, well, this isn't really a constructive trust, it's a statutory constructive trust. And you read into the statute, it talks about proceeds and fruits, and you can go read their briefs, and my computer's count of proceeds and fruits was the term was used 104 times in the opening and reply brief. And they can use it that many times, but the fact of the matter is there's no difference between the statutory constructive trust and what an equitable constructive trust is. I mean, we're in the exact same place that we were in the ML case, that we've got a constructive trust. A constructive trust is a constructive trust is a constructive trust. And the court really need look no further than the Carruthers v. Underhill case, which dealt with a statutory rescission remedy under the securities fraud statute. And this court held there that where the statutory rescission remedy merely echoes the equitable remedy, it's the same thing and it ought to be treated the same way. It gets no special enhanced characteristics by virtue of appearing in a statute. So really, for the 3 reasons that I just laid out, ML Servicing versus Coles in 20-1131 bars plaintiff's claim on a motion to dismiss. The Marsh Group's a creditor of a person who affected the life insurance, however they want to argue it. The policy proceeds are not property and not subject to a constructive trust, and there's no difference between a statutory constructive trust and an equitable constructive trust. So the analysis in ML versus Coles controls. And with that, I'm going to hand off to my colleague.
May it please the court, my name is Jerome Elwell, and together with my partner Phil Wisnansky, we represent Francine Coles and her children, also the Coles defendants in this case. Your Honors, in addition to the life insurance policy proceeds being exempt, in addition to the constructive trust not being available where there are adequate remedies at law, and Arizona's insurance statute provides that to these plaintiffs, they chose not to avail themselves of that. We have 3 other arguments that suggest that the trial court was appropriate in dismissing this claim. First, 13-23-14-04 D6 unambiguously requires a determination of liability before remedies will flow. Second, the same statute subsection A unambiguously prohibits the assertion of conduct that would be actionable as fraud in the purchase or sale of securities from being relied upon as a predicate act under the RICO statute. And finally, Your Honors, that Section L of that same statute unambiguously precludes the imposition of liability or other relief against non-culpable defendants. And Judge Norris and Judge Gould, you asked a very good question about subsection L. I'll start there because I was intrigued. What happens if the plaintiffs go back down to the trial court and they want their $40 million or their $50 million, and there's a judgment of $50 million against Francine Coles and Ashley Coles, and they spent $10 million of it? They're going to want a personal judgment against Francine Coles and Ashley Coles for that $10 million. Subsection L precludes that. They can't get it. Turning to D6, I'll back up now. Turning to the unambiguously requiring a determination of liability before remedies will flow. The plaintiffs argue that despite what that statute says, that they don't need to obtain a determination of liability before a constructive trust will follow. All they need to do for, and they put this in quotes, for a determination of liability is prove that the person who originally acquired the property did so through an offense enumerated in the RICO statute. But how do you determine whether a person who originally acquired the property did so in violation of the RICO statute without a determination that that person is liable? You can't get there. They want to render that part of the statute completely meaningless. They want to skip over it.
You know, I'm not sure I completely agree with that. And what would preclude the Marsh plaintiffs from seeking that determination of liability through a declaratory judgment that the RICO defendants, the law firms, the financiers, the accounting firms, had committed RICO violations? So why couldn't they seek that through a declaratory judgment action?
In this case, they can't do it because of the procedural status of the case. Now, the plaintiffs will tell you that they settled with the financier and accounting defendants, but that's not an accurate statement of the law of the case in this matter. At the trial court level, the trial judge dismissed the claims of RICO against both of those purported actors. So when we go back down to the trial court, if we go back down to the trial court, they can't ever make that assertion.
That's a very good point, and I noted that. But what about the law firm?
Good question, and thank you for asking.
You're welcome.
As part of, well, it's in my notes, so I'm really glad.
Okay.
If it weren't in my notes,
I worked on this. Okay, I was thinking about this case. Okay.
Thank you, Your Honor.
Okay.
And we have as well.
You have. Both sides have.
The law firm defendants in this case filed a motion to dismiss. Mm-hmm. Before the motion to dismiss was even ruled upon, the parties entered into a settlement agreement. Mm-hmm. That settlement agreement it absolved anybody of liability, okay? But they went one step further, they being the plaintiffs. They entered into a bar order. They entered into a bar order that precludes them from ever seeking to have liability imposed against. I'm sorry.
I've read it. I know what you're talking about.
It's that section B,
right.
9B, mm-hmm. where it says the court completely and permanently bars and enjoins any and all persons and entities from commencing, prosecuting, or asserting.
Well, that's true as against the law firm defendants.
Those are the only people there.
Well, let's think about that. A declaratory judgment action. I am the Marsh plaintiffs, and I allege that the lawyers, we're just talking about the lawyers, committed or participated in or in a RICO violation with the Mr. Cole and the other defendants. It is true I cannot get a judgment against the lawyer defendants, but can't I seek a declaration
you can't
that
even
the lawyer defendants were in fact, they violated the RICO statute? Now, I can't enforce it against them, but I can get a declaration.
No, Your Honor.
Why can't I do that?
Because of what I just read. The court completely and permanently bars and enjoins any and all persons from asserting any claim. You can't even assert.
I'm not, but it goes on, asserting a claim against. There's no against here. The defendants, the lawyer defendants, are not in this case. There's nothing against them. I'm just seeking a declaration of rights and remedies. My rights and my remedies.
Okay. And then I would fall back on my fallback argument, which is we're well past the statute of limitations where they could bring any claim against any defendant for arising out of RICO at this point in time. We're
But
well
the claim
past.
isn't against the RICO perpetrators. My claim is to seek a declaratory judgment against the Cole defendants that they have received, we'll put aside for the moment property, proceeds, insurance benefits, but they received assets through a racketeering violation. So can't
Okay.
I get a declaratory judgment that yes, there was a racketeering violation, and that and that my rights or remedies, if I was right on the other issues, I would have some remedies under the other provisions of the RICO statute.
I don't think so.
Okay.
I don't think so because the Coles defendants, if there is liability, it's derivative. It is derivative of the liability of the bad actors in the illegal enterprise. Okay? And in order to get to them, to the Coles, you have to prove that somebody did something wrong. You have to have a judgment, a determination of liability. It doesn't matter that you're not trying to impose it against them. You can't even ask for it. And here, they've extinguished the liability of the purportedly bad actors.
Do you have any, what's your best case on that?
Yes,
That you would-
absolutely,
you
Your
would
Honor. It's
say-
the Jamerson v. Quintero matter.
Okay.
And I'll go through that with you. The Coles defendants, I think we can all agree, if there was no purported bad acts under the RICO statute, we wouldn't be looking at the Coles defendants. Their liability is derivative of the bad acts of the purported bad actors
They're
under
a
the RICO.
recipient of alleged bad actors.
Okay.
Go ahead.
And the trial court extinguished the liability of
The bad
two of the three bad actors. And the plaintiffs extinguished the liability of the third.
Right.
Okay. Now, under the Jamerson v. Quintero case, once they extinguish the liability of the bad actor, the derivative liability is likewise extinguished. In that case, the court said,
Remind me, in Quintero, who were the derivative defendants?
in
Wasn't
Quintero,
the agent released?
the agent was released.
And the
agent
issue
in
was
principle.
Correct.
The issue was whether there could be liability against the principal
that's-
when the agent had been released.
And in that case, they said the principal can, once the agent is released, the principal's liability is released. But that's not what happened in that case. Quite frankly, Walgreens settled the claim, and they wanted to go after the janitor that left the water on the floor. And the janitor said, no, my liability is derivative or part of Walgreens' liability. They failed to maintain the premises in a safe and reasonable condition. And the court said, no. Just because we dismissed the principal doesn't mean that the actor is gone. But the opposite absolutely applies.
But there you're talking about two people, an agent and a principal, as opposed to a mere recipient of proceeds. I mean, I'm looking for a case that, let's say, you have a mafia figure. Okay, and I'm not, this is devoid of this case. Okay, this is a hypothetical. You have a mafia figure, defrauds hundreds of people, gives all the proceeds to an innocent person, and then you can't get a judgment against him for whatever reason. He's dead, there's a settlement, he's, for whatever reason, you cannot get a judgment against him. Statute of limitations is run against him. You're saying that you couldn't then try to go against the recipient of it to get an innocent recipient because you could, simply because you couldn't get a declaration that maybe he had done this, even though you're not seeking liability against him. You're seeking just to get a constructive trust. You're saying that the agency in principle then translates over to a mere innocent third party, and all you're seeking is a declaration?
In answer to your question, Your Honor, I turn to subsection L. And I would say an innocent third person, an innocent party cannot be held liable for the actions of another.
I understand that. But I'm just looking at your
Well, they all,
argument about...
I didn't mean to interrupt, but they all interplay with one another, Your Honor. This is a statutory scheme that's designed to punish the wrongdoers and protect those who had nothing to do with it.
And what do you do with C about the provisional? That's your provisional remedy argument?
I'm sorry, Your Honor. I didn't understand the question.
I'm sorry. Before a determination of liability. 231404C.
What do I do with it?
I understand your point is that's just a provisional remedy.
Exactly. It even says right there in that section that there's got to be a hearing or other proceeding to protect the innocent party, to make sure all parties' rights are protected. That's nothing more than a provisional remedy action. Your Honor, our next argument is that, well, the plaintiffs say that we would punish them if we allow for them, if we preclude them from settling with these defendants. And I remind you, they didn't settle with these defendants. 2 of them were dismissed, and the law of the case is they're gone. Mm-hmm. And their private settlement with those defendants after a determination that there could be no liability doesn't change the law of the case. The next argument that we make is that we rely on Section A. No person may rely on any conduct that would have been actionable as fraud in the purchase or sale of securities to establish an action under this section. Now, the plaintiffs don't deny that they have expressed conduct which they rely upon, which would be actionable as fraud in the purchase or sale of securities. They don't deny that. Instead, they say, we didn't rely on it, we didn't plead fraud in the sale of securities as a predicate act, and therefore that section doesn't apply to us. First of all, the statute isn't read that way. It takes the plain meaning of the statute and twists it all about. But more importantly, it flies in the face of case law that we have cited to you. That's the Bald Eagle Area School District v. Keystone case. In that case, the court made it clear that it's the conduct that matters, not the predicate act that's chosen by the plaintiff to assert. A plaintiff cannot avoid, says the court, the RICO amendments bar by pleading mail fraud, wire fraud, bank fraud as predicate offenses if the conduct giving rise to those predicate offenses amounts to securities fraud. Allowing such a surgical presentation of the cause of action would undermine the congressional intent behind the RICO amendment. So they claim that we don't, just because we didn't plead it, that doesn't apply. And the law says otherwise. And common sense and common unambiguous reading of the statute says otherwise. Finally, Your Honors, we've talked about Section L in brief. And I see that I'm out of time. So unless you've got questions, I will retire. Thank you.
Thank you.
I want to return to the issue that Judge Norris raised about a possible declaratory judgment action. First, I think that I don't have the bar order in front of me, so I can't read to it from you, but I'm confident that my recollection is correct that there is a carve-out for the constructive trust claim in that bar order. Second, there are still defendants in the case that are alleged to have been members of the illegal enterprise. One example is SMC Revocable Trust. The claims against it were defaulted because it never appeared. But there are still parties that are parties to the case against which there could be a declaration that they engaged in racketeering, that they committed a pattern of racketeering activity, and that could serve as the basis for a determination of liability. So there still are parties in the case, and there were others who were not named as parties. If you look on page 3 of our complaint, we list the alleged members of the illegal enterprise that were not part of settlements. A second issue was with respect to the ML Servicing Co. case. In that case, this court talked about that ML groups had an adequate remedy at law, and that remedy was provided by subsection B of the Life Insurance Exemption Statute. Here the Marsh Group has a remedy at law as well, and that's provided by subsection D6 of the racketeering statute. It's a constructive trust, true, but it has also been engrafted into a statute and becomes a remedy at law just as much as the constructive trust type remedy in Section B of the life insurance exemption statute is a remedy at law.
Doesn't the Carruthers case conflict and undercut that argument?
I don't think so. The Carruthers case is all about whether when you settle with the principal, the agent is no longer liable.
Well, there's an aspect of that, but it has there's quite a significant discussion about constructive trust and the fact that the remedy, the equitable remedy sought there was statutory, didn't change the law applicable to that remedy.
Yeah, in that case, it was about the Securities Acts and the rescissionary remedy.
Right.
And the court's discussion was that equitable defenses still apply when you seek rescission, where the statute simply says that one of the possible ways that you can seek damages or you can seek rescission. And the court in that case said the fact that you can seek rescission doesn't mean that suddenly you can't assert equitable remedies. So I don't think that conflicts with this case. I think that in this case you have a constructive trust that's been engrafted into a statute the same way that in subsection B of the life insurance exemption statute, the legislature said, look, if it's a fraudulent transfer, we're going to allow you to recover what was the premiums that were paid. That in constructive trust at common law, you could do the same thing. And so it's been engrafted into that statute, and this court called that a remedy at law. We have the same thing here. There's a constructive trust that's been engrafted into subsection D6, and it is now a remedy at law in that sense. In my little time left, I just want to talk quickly about the securities fraud exception. In our case, what we relied on was the sale of unregistered securities by Radical Bunny as part of a unitary financing scheme, and then the transfer and use of those proceeds, which was money laundering. None of that was a fraud in and of itself. Whereas the federal cases cited by the Coles are all about allegations of bank fraud, wire fraud, other forms of fraud that also involve securities. Those were the predicate acts relied on. We're not relying on some other form of fraud to prove our underlying RICO claim. We're relying on acts that don't require fraud. And with that, my time is up. So unless you have any questions, I will sit down.
Thank you. Thank both counsel for their arguments. We will take this matter under advisement and issue a written decision in due course. With that, we stand adjourned. Thank you.